Good afternoon, everybody, and welcome to the panel discussion on From Separate But Equal to Affirmative Action, where we are 70 years after Sweatt v. Painter. I'm Pamela Herndon, a member of the African-American Affairs Committee of the Civil Rights and Social Justice section in the American Bar Association, and we are excited about the panel discussion that you will be a part of this afternoon. But before we introduce you to the moderator, I would like to introduce you to the leadership of the African-American Affairs Committee. Please give a warm welcome for Angela Dean Scott. Angela, would you please stand up? So I'm going to introduce you to the moderator for today. He is an emeritus professor of law and a former co-dean of the University of New Mexico School of Law. And prior to joining the faculty, he was a member of a large law firm in Denver, Colorado. He is a graduate of Howard University, and he received his JD from Yale University. He is known in his community as an academician, as a scholar, and as a go-to person in the community. I am so proud to introduce you to none other than Dean Emeritus Alfred Dennis Mathewson.
I was going to say welcome and thank you for coming to the panel, but you've already heard that. Before I introduce the other members of the panel, I wish to provide a little background about Sweatt v. Painter. Heman Sweatt applied for admission to the University of Texas School of Law on February 26, 1946. The president of the university requested an opinion from the Texas Attorney General. The Attorney General was of the opinion that under the separate but equal doctrine, the University of Texas must admit Heman Sweatt unless the state offered him admission to a law school with equal educational advantages. Then, the regents of Texas A&M University established a program of legal study at Prairie View University. The trial court held that the separate but equal doctrine was satisfied, but no one applied to the Prairie View program. The state legislature then established Texas State University, now known as Texas Southern University, and established it with a law school in Houston. And then the Supreme Court held that the legal education available to Sweatt at that law school was not the equivalent of that offered at the University of Texas, and he was admitted. So separate but equal remained the law of the land until Brown versus Board of Education. In Gaines versus Missouri, the Supreme Court had given states the green light to comply with the separate but equal doctrine through the formation of public HBCU law schools in 1938. North Carolina Central University Law School was established in 1939. The Southern University Law School was opened in 1947, and Florida A&M University opened its original law school in 1949. There were some southern states that sought to comply with the separate but equal doctrine by paying tuition of African Americans to attend law school out of state, and in fact, the first black graduate of the University of Mexico was from Alabama, and the state of Alabama paid his tuition. So Gaines preceded Sweatt, which preceded Brown and Bakke and Hopwood and Grutter and the Fisher cases. And now students for fair admissions versus Harvard is in the courts, and it is 70 years later. And this panel has been tasked with focusing on the progress or lack thereof post-Sweatt v. Painter in the support of aspiring African American and other students of color to attend law schools, whether at historically black colleges, historically white institutions, or whether public or private. So now let me introduce the panel. Dean Joan Bullock, who is sitting second from my left, is the Dean of the Texas Southern University Thurgood Marshall School of Law. Formerly, she served as the president and dean of the Thomas Jefferson School of Law in San Diego. Prior to that appointment, she was a senior founding faculty member and the Associate Dean for Teaching and Faculty Development and Acting Associate Dean for Academic Affairs at the Florida A&M University College of Law. She is a Michigan lawyer and CPA who has practiced before the United States Tax Court and assisted many startup enterprises with general counsel and CFO services and law firms with business advisory services. She is a past chair of the American Bar Association's Law Practice Division and currently serves as one of the division's delegates in the ABA House of Delegates. She is a fellow of the American Bar Foundation and a member of the American Bar Association Science and Technology section. And she is the author of How to Achieve Success After the Bar, a step-by-step action plan. Welcome, Dean Lowe. Dean Ward Farnsworth taught for 15 years at the Boston University Law School, where he also served as Associate Dean for Academic Affairs before his appointment as Dean of the University of Texas School of Law. Dean Farnsworth is a reporter for the American Law Institute's Restatement Third Torts. He has published scholarly articles on a range of topics in the Columbia Law Review, the University of Chicago Law Review, the Michigan Law Review, and various other journals. He teaches courses on torts, contracts, civil procedure, admiralty, and rhetoric. He served as a law clerk to Anthony M. Kennedy, the Social Justice of the United States Supreme Court, and to Richard Posner, Chief Judge of the United States Court of Appeals for the Seventh Circuit. He has also served as legal advisor to the RAND United States Claims Tribunal in The Hague. Welcome, Dean Farnsworth. Professor George A. Martinez joined the faculty at Southern Methodist University in 1991. He was a teaching fellow prior to that in the Department of Philosophy at the University of Michigan and a visiting assistant professor of philosophy at Texas Christian University, and then came to law school, and he became a litigation associate at the Chicago firm of Lyle, Brown & Platt and with the San Francisco firm of Morrison Forster. Professor Martinez has published extensively in the areas of race and the law, federal courts, legal history, and jurisprudence. He is associate editor of the NAFTA Law and Business Review of the Americas. Welcome, Professor Martinez. Dean Emerita Drusilla Stendhal-Raymond has for 40 years served as a national leader and spokesperson on equality access and opportunity in the justice system. Formerly a civil rights litigator at the Mexican-American Legal Defense and Educational Fund, she served as the longtime executive director and general counsel of the Bar Association of San Francisco and as executive director of the National Association of Women Judges and dean of Golden Gate University School of Law. She's the first woman chair of the ACLU of Northern California. She also chaired the San Francisco Commission on the Status of Women and was co-founder of the California Minority Council Program and numerous other diversity initiatives. Welcome, Dean Ryan. Now, it is fortuitous that the mid-year meeting is in Austin, because this is a very apropos place to have a discussion about Sweatt v. Painter and why this come after us. And so each panelist is going to speak, and then I may ask them some follow-up questions or let them ask each other questions, and then we will have questions from the floor. We're going to start with Dean Farnsworth, University of Texas, where it all began.
Indeed. All right. Well, thank you so much. It's an honor to be a panel with such great people, and I appreciate everyone's interest in Dean Sweatt and his legacy. So we realized at our law school some time ago that there was actually no visible tribute to Keevan Sweatt or sign that our law school was the site of Sweatt v. Painter. If you were a student, you had heard about the case in class, like students at every law school do, but there was no sign in the law school that it was connected with us in a particular way. And I suppose that might be because, of course, it's a painful thing to be the law school that had to be sued by Keevan Sweatt for him to be able to attend. But part of our goal has been to embrace that legacy and make it a source a kind of pride that he was our student after he fought to get in. And we ended up reaching out to his family and getting a bunch of photographs of him that we could use to work with a painter who specialized in painting from photos. And we created a really nice oil painting of him and Sweatt, which hangs in our atrium next to a picture of a copy of the letter that Farouk and Marcia sent him when he got in. We had a wonderful ceremony to unveil this. We had even Sweatt's daughter. He has a daughter named Hamela, who's a physician in Cincinnati. And she came to our school with her kids, and it was and some other family, and it was really a joyous thing to try to celebrate and take ownership of this feature of our school's legacy. And so the question then becomes, what does it mean for that to be a living legacy, not just an oil painting, but something that you're actually learning from and doing something about? And I think some of that requires us to think about what are the features of our institutions now that are going to cause us to look back with pain and embarrassment 50 or 70 years from now. I mean, anybody can look back on something and say, gee, how did we get into that situation? I'm already sorry. But the interesting question is, what are you doing now to try to avoid having to say that much later on? So that's something we can perhaps talk about in the question and answer session. But on a more basic level, of course, we're committed to having a diverse student body and making our school a welcoming and wonderful place for all of our students, especially members of underrepresented groups. We do a lot of things to that end that are the things I suppose many schools do, but a great deal of outreach and attempts at mentoring from our alumni and current students to members of our underrepresented groups who apply to our school, attempts to recruit those students to become applicants, but with a lot of visits and personal time at HCBUs and other institutions where we can meet and work with undergraduates, African-American undergraduates, members of other underrepresented groups. And our schools involved in these law school preparation institutes that are held at public universities, undergraduate institutions around Texas, where we send faculty to work with undergraduates who are seeking to go to law school, trying to increase their chances of success once they get there and of getting into ours. There are also some money issues that are probably more relevant now than they were. I'm just trying to think, how has the world changed on these issues in the last 10 or 20 years? And part of what's happened is, of course, law school's gotten more expensive, and a lot of applicants are more money sensitive than they used to be. So I think there's more competition when it comes to underrepresented groups, with just scholarship offers. I mean, every law school, every dean wants very much, that I'm aware of, wants very much to have a diverse class with lots of different kinds of students in it. And in one interesting respect, I think public schools can sometimes be at a disadvantage in this way, in that private schools are free to, and often do, raise their tuition very dramatically, and then redistribute the tuition between students at their schools. And those of you who work at law schools know all about this, what I'm talking about, that often, the bottom half of the class in credentials ends up paying for the top half of the class, in fact, or in some cases that money can be redistributed to groups that are underrepresented that you're trying to attract to your school. But our school, my school, doesn't actually do very much of that because we cannot easily raise our tuition, and we don't really want to. We're a public school and we're trying to be less expensive. So I think Columbia and Harvard now have tuition of maybe $70,000 a year, whereas at my school it's $35,000, about half that, which is still, to me, a sort of shocking large amount. On the other hand, it's very little compared to other places. It's all relative, I guess. I suppose most of us went to law school at the time, but it was much less expensive than any of these figures. But in any event, we just have less money to redistribute. Most of our financial aid comes from endowments that our alumni generously create. We're not using the high amount of tuition we get from one student to pay another. And that sometimes creates competitive issues. But, those issues are mostly about competition between schools. And I'm not sure if they really go to the social issue, which is how many African-American students are going to law school. And roughly what kinds of law schools are they going to, and then what are they doing afterwards? There are a couple of law schools, there's some differences between law schools, but at most schools over the last 10 years, the number of African-American students has been pretty steady. The total number of African-American applicants to law schools has been pretty steady. It hasn't changed that much. Neither has the number at any given law school changed that much. It's usually sort of a band or a range, and there's some movement within that range, but the range doesn't really change that much. And so I find myself wondering, well, what might change it? Like, are we going to be sitting here in 10 years having the same conversation about the same numbers? Well, we certainly could. We could be in that position. What would it take for us to really be in a different position then? And one thing I think about is, so many of our social problems are really intractable and or very hard to figure out because they involve massive collective action problems or coordination problems, huge institutions that are very hard to change. There is one thing that could be done that would be much simpler than any of that I think would make a difference, which is if you as a World Report stopped ranking schools based on median LSAT and GPAs of their incoming students, I think that would actually make a very substantial, well, that would be that, I don't expect it to happen, but it wouldn't be that difficult to do. They could just do it. And if they did it, I think that would actually change things pretty considerably. Because right now, whenever a law school engages in affirmative action, it suffers a kind of rankings penalty or pain. And then, law deans are all answerable to alumni and administrators in these situations. And so it creates sort of a countervailing pressure. If that pressure were removed, I think it would do a great deal to enable law schools to allow and encourage law schools to diversify more than they already do. Whether that's going to happen, I don't know, but that's the easiest tweak I can see to our current institutions. It can be done tomorrow, and I think it'll be quite impactful. Anyway, I look forward to more discussion and Q&A at the end of our presentations. Thank you.
Sweatt v. Painter was about more than the University of Texas, that Texas Southern, the Thurgood Marshall School of Law was also involved, and now we will hear from Dean Bowe.
Thank you, Professor Emeritus. Matthews. Can you hear me?
Yes.
Okay, wonderful. As was mentioned, I am the Dean of Thurgood Marshall School of Law. And Thurgood Marshall School of Law is known as the house that Sweatt built. Because of the Sweatt versus Painter case, the Texas State University's School of Law, or the Texas University School of Law for Negroes was founded, and that was established in March of 1947. And initially, it was started on an interim basis in Austin, Texas, while the building was being constructed in Houston. But it started first in Austin, and at that time, there were professors who were going back and forth from UT to the basement in this building in Austin to teach the 3 students who were at the Texas State University for Negroes and its School of Law. The Texas State University moved to Houston in 1948, and it was renamed the Texas Southern University in 1951. It had a pretty tumultuous time because at that time there was the civil rights movement, there was the more and more blacks were complaining about their condition and wanting to be full-fledged citizens of the United States and all its privileges. And so Thurgood Marshall, if you look at all the cases, the Missouri-Israel Gaines versus Canada, Sippuel versus the Board of Regents of the University of Oklahoma, the Sweatt versus Painter case, Thurgood Marshall was the attorney involved in that case, and he was very much an integrationist. He was not content to have the separate but equal laws continue. But it was an opportunity for him throughout these cases to really push to ensure that separate but equal be found unconstitutional, as it was later found in the Brown versus Board of Education case. With Sweatt versus Painter, when it was determined that it was separate, but it wasn't equal. The facilities were not equal. The reputation of the schools were not equal. The exchange in the classrooms was not equal. And therefore, Mr. Sweatt should be entitled to attend the University of Texas School of Law. But with Texas Southern University's law school continuing, it was an opportunity for blacks to be able to go to a school where not everyone was as fortunate as Mr. Sweatt, not everyone was as fortunate as Ada Sippuel, not everyone was as fortunate as Mr. Gaines. If he was, as you may know, he disappeared and they could not find him. But HBCUs have a special place in educating blacks. And I want to just digress just for a moment as it relates to me personally. I was raised in Montgomery, Alabama during the early 60s. And I remember the laws then where segregation was illegal, but it was still very much, very real for blacks. So I can appreciate Thurgood Marshall during a time in his struggles when he was trying to push for blacks to have, to be fully invested in this country, in being able to be full citizens and the full rights and privileges that comes with being a citizen of the United States. And I wrote an article when I moved to San Diego to be president and dean of Thomas Jefferson School of Law in the San Diego Lawyer, and it's called Moving Beyond the Place. Because that is exactly, I think, what this discussion today deals with, us moving beyond the place. There is a place that for blacks generally, and for other persons of color, where you just know this is your place. And moving beyond the place. And one of the things that I wanted to get across to the students when I was at Thomas Jefferson, and even as students at Thurgood Marshall School of Law, and also when I helped to reestablish the Florida A&M University School of Law, was that we need to move beyond the place. The laws that are in place have a lot to do with structural injustices in this country. My concern with the way, the question that is stated, from separate but equal to affirmative action, where are we 70 years after Sweatt versus Painter, cannot be answered completely without looking at structural racism, both visible as well as invisible. To a certain extent, persons of color are still operating within that place. I am finding, especially in the HBCU environment, where it is important to help many times first generation students, first generation college students who are now first generation law students, where they are trying to navigate beyond that place. And it's not easy. As was mentioned by Dean Farnsworth, when it comes to a lot of, it's not just a financial situation, it is a lot of the social ills within society that inform or cause a lack of information to persons of color when it comes to being in an HBCU environment. And so when we ask the question of where are we from Sweatt to affirmative action, the question is, how have we facilitated that movement from that place where people have been conditioned to living in a certain situation where they are expected to operate in a certain way and not get beyond that place. So that is problematic for me when it comes to working in an HBCU environment, and the question that hasn't come up yet, but I will raise as to what's the continued viability of HBCUs. Are they still needed? And I would say they are. The Thurgood Marshall School of Law, of course, is named after Thurgood Marshall, and there was some concern by him as to whether he wanted to lend his name to a Jim Crow institution when he fought so hard to break down the whole Jim Crow system. But he understood the importance of giving opportunity, or having a venue by which, an avenue by which persons of color, and particularly blacks, could have the ability to learn about the law and to be able to advocate for themselves. So he lent his name to the institution, and it's important that we at the Thurgood Marshall School of Law live up to his name and his legacy. But with that, the HBCUs, and particularly Thurgood Marshall School of Law, has graduated more African American attorneys in the state than the other law schools in Texas combined. So that says something about the importance of the HBCUs and allowing for those who may not be considered worthy of attending other law schools to come to Thurgood Marshall and not only become practicing members of the bar, but also being able to advance community interests in communities of color. So HBCUs are very much needed. They are very important. They are also important for helping to educate those who are first generation law students to learn more about how not only they can be fully invested as citizens here in this country, but also to help other persons of color to become fully invested as well. Thank you.
Next, we would hear from Professor Martinez.
Thank you, Alfred, for the invitation to come here and to have the opportunity again to look at this case and to think about the case in terms of what the case meant then and what the case means now. What I propose to do in my remarks is to look at the case in light of critical theory, including critical race theory that has been developed since the time of Sweatt v. Painter. And so some of the facts are important to understand the meaning of Sweatt then and what it means now. So I'm going to go through a few of these facts of the case. Sweatt v. Painter was decided during the Cold War in 1950 and was a test case brought by the NAACP and its lead attorney, Thurgood Marshall, seeking to desegregate the University of Texas School of Law. Marshall hoped to use the case to compel an end to segregation in education. Rather than integrate the University of Texas in the 1930s, the Texas legislature voted to establish an out-of-state scholarship program, which would enable African Americans to pursue graduate education outside of the state of Texas. The fund, however, did not have sufficient money to support all black students, resulting one year in about 60 African Americans being denied funding. In June 1945, the Texas legislature passed legislation to establish courses in law at Prairie View A&M, and the courses were supposed to be substantially equivalent to those taught at UT. In February 26, 1946, Heman Sweatt tried to register at UT Law School. At the time, there was no law school in Texas for African Americans anywhere in Texas. The UT school registrar told him he could get funding to go to school elsewhere. Mr. Sweatt said he did not want to go out of state to school. The Texas Attorney General informed Sweatt that although Sweatt was academically qualified for admission to UT, the wise and long-continued policy of segregation of races in educational institutions should continue. Sweatt then brought a lawsuit against UT in April 1946 seeking admission, contending that the failure to admit him violated his rights to equal protection under the 14th Amendment. The judge held that if the state of Texas established a course of legal instruction substantially equivalent to that offered at UT, the Sweatt request would be denied. UT and Texas A&M then quickly tried to set up a separate but equal law school. After 6 months, there was still no black law school. Nevertheless, the judge denied Sweatt's application. Sweatt appealed, and the Court of Appeals remanded the case to the district court for a hearing. In March 1947, the Texas legislature quickly appropriated $2.75 million to set up TSUN, the Texas State University for Negroes. One Texas senator had said that if we don't do something quickly, the U.S. Supreme Court will rule that your child and my child will have to attend school with blacks. The state of Texas then set up a temporary law school in Austin in the basement of a building near the state capitol. The school had only one furnished classroom with 6 desks and a blackboard. The other classroom was empty. The part-time dean of the black law school was the dean at the University of Texas also. There are also 3 faculty members from UT. No black students registered for the spring term at TSUN. Sweatt refused to enroll because he opposed segregation. On remand at a hearing in 1947 in Austin, there was testimony from experts that TSUN gave blacks an equal opportunity to study law. Physical facilities were substantially equal. They also testified to those offered at UT, and that TSUN was equal, if not superior in every respect to the UT School of Law. Judge Archer again ruled in favor of the state. Sweatt's attorneys eventually took an appeal to the U.S. Supreme Court and argued the case. In April 4th, 1950, the court handed down its decision in favor of Mr. Sweatt, holding that the legal education offered petitioner was not substantially equal to that which he would receive if admitted to UT. Now, Sweatt v. Painter was decided in 1950, and since that time, contemporary critical theory has developed powerful tools that may be used to analyze issues of race, such as those presented in Sweatt v. Painter. And here I want to analyze Sweatt and its legacy through the lens of critical theory, including critical race theory. Sweatt v. Painter and the geography of race. Critical geographers of race analyze issues of race and racism. Geographers of race have recognized that the whiteness of the dominant group operates as an epistemology. In other words, whiteness is a particular way of knowing and valuing social life. In this regard, the epistemology of whiteness operates to create a distance between whites and minorities in the social spatial world. Thus, the races are largely segregated in racialized geography in America. Applying these ideas to Sweatt v. Painter, we see how the state of Texas sought to create a distance between the Anglo majority and blacks. First, rather than integrate the University of Texas School of Law, the legislature set up a program to fund black students so that they could pursue legal studies outside of the state of Texas. Next, rather than integrate UT, they set up TSUN and leased a temporary location in the basement. In these ways, the dominant group sought to maintain a distance between themselves and African Americans. As to this distance, the writer James Baldwin suggests that we should ask several questions. First, who established this distance? Who is the distance designed to protect? And from what is this distance designed to offer protection? Baldwin suggests that the distance between whites and people of color is constructed to protect whites from feelings of guilt. Critical geographers who analyze geographies of exclusion have also recognized that power is exercised in the construction of space and that the dominant group relegates weaker groups in society to less desirable environments. The facts of Sweatt reveal an effort to consign a weaker group, blacks, to an undesirable geographical environment. Blacks were relegated to an unappealing landscape, the small basement law school, as opposed to being allowed to attend the highly desirable UT School of Law. Geographers of race also have observed that the geographical boundaries between the dominant group and racial minorities are drawn to prevent minorities from polluting the space of the dominant group. And so minorities are excluded from certain environments, allegedly to prevent them from introducing undesirable things into the environment. In this regard, the comment of the Texas senator regarding the urgent need to create the TSUN seems to express a fear of such pollution when he asserted, if we don't do something quickly, the U.S. Supreme Court will rule that your child and my child will have to attend school with blacks. So in summary, the Sweatt v. Painter case implicates an epistemology of ignorance, an epistemology of whiteness, that created a white geographical space in Texas and at the UT Law School. And this conclusion is consistent with critical geographical insight that the world is wholly racialized, with the fact that racial subjugation in America has a spatial value where historically the power of the state has been deployed to protect white space. Well, what does Sweatt v. Painter mean now? What does critical theory tell us about the meaning of Sweatt v. Painter now? Sweatt v. Painter is a decision in the U.S. Supreme Court that may be explainable by interest convergence theory. That's a central part of the critical theory toolkit. Critical race scholar Derek Bell contends that with respect to racial minorities, when the white majority acts, it acts out of self-interest. As a result, racial minorities can only improve their condition if it's in the interest of the dominant group. And the argument is that at that time we have decisions like Brown v. Board of Education because that advanced the interest of the majority in the U.S. They were trying to compete with the Soviet Union, and as a result, they had to begin to desegregate our schools because they were being heard abroad as the Soviet Union contended that the U.S. was a racist country. The problem now, that critical theory points out, is that the Soviet Union is no longer there to act as a check with the fall, the disintegration of the Soviet Union. Now, critical theorists argue that the assimilation or integration of minorities is no longer an important goal in this country. And so, if you notice, there are 20, more than 24 of the judges that President Trump has appointed were unwilling to say that the Brown v. Board of Education decision was correctly decided. So we're in a time that is potentially dangerous in terms of preserving the ideals of integration, desegregation, and so on. There's a danger of returning to the old ways.
We will now hear from Dean Ryman, who will take us beyond Texas and not just public law schools, but also private law schools, and with not just African Americans, but others, students of color as well.
Although I'm going to really focus on African Americans here, but well, first of all, when I think about these issues, it's not so much as somebody who worked at MALDEF or even as a law dean, but really my 142 years as the executive director, general counsel of San Francisco Bar. It seemed that way from 1985 to 2002, and we really poured in literally millions of dollars, most of it from, oddly enough, Wells Fargo Bank, to try to do something about what our studies showed to be segregation in the legal profession in San Francisco. So we tried every program we could think of, including founding the California Minority Council program because Dennis Archer ordered us to do so. But we really then tried to export across the country programs that we thought had actually worked well. But those really were, from the point of view of the non-historically black colleges and universities, were kind of the halcyon days, really, of affirmative action. And there was a lot of optimism when we passed very aggressive goals and timetables that with the pipeline doing as well as it seemed to be from both kinds of schools and from both public and private non-historically black schools, that we could heed Justice Blackmun's admonition that in order to get beyond racism, we must first take account of race. There is no other way, he said. We dare not let the Equal Protection Clause perpetuate racial supremacy. So our goals and timetables were really based on this pretty robust pipeline. In fact, if you look at the figures, and believe me, with the way the ABA is now carrying the figures on this, it's not easy to find. But basically, the percentage of minority law students, primarily Mexican American and African American law students, tripled from 1971 until 1996, the year that began the onslaught of anti-affirmative action initiatives that we all know something about. And so this trend really ground to a tragic halt with the passage in California of Proposition 209 and subsequently its progeny in Washington State, Florida, thank you, Jeb Bush, Arizona, Michigan did it in an executive order, Michigan, Nebraska, New Hampshire, and Oklahoma. And there would have been more had the NAACP Legal Defense Fund not stopped several of those in their tracks because they were based on fraudulently collected signatures. So in the ensuing 25 years since the passage of 209 and its progeny, basically the subsequent growth, which has been about 10% more, has really been almost entirely due to certain Asian American groups and to non-Mexican American Hispanics, which are largely, I would argue, Cuban Americans, but because of the way the ABA keeps its figures, it's hard to know. But basically, the numbers and the percentages of African American and Mexican American students have remained essentially flat after first taking a huge dive, in California at least, after the passage of 209. So after 209, Berkeley Law, which was then called Voltall after a obviously confirmed racist, so they've changed their name, enrolled but one African American immediately after the passage of Proposition 209, having had several dozen African Americans for many years before that. And that guy was deferred from the year before, so they actually had none that year. Overall, the representation of African American students in California's distinguished public law schools fell by about 60%, and that of Mexican Americans by about 33%. Similarly, today, in the Harvard case, which is brought under Title VI against Harvard as a school that receives federal money, in that case, Harvard at the trial, and as was articulated by the judge in that case, said that if affirmative action were eliminated at Harvard Law School, college, African American enrollment would fall by 57%, similar to what happened in California. From 14% to 6% of the class, and Latinx enrollment would fall by 36%, again, very similar to what happened in California, from 14 to 9% of the class. And that over 4 years, there would be 1,000 fewer African American and Mexican American and other Latinx students. So if that case actually gets to the Supreme Court and goes the wrong way, then it will really disastrously affect many, many private schools that have enrolled relatively large proportions of African American, especially students, including Columbia, Georgetown, and of course Harvard, and a variety of other schools. I'd like to say that that was very much, I think, the intent of the people who worked for the passage of 209. They wanted that to happen, and that is exactly what's happened. I can't but digress here for a minute and simply say that this is in sort of a comparison to the legacy preference, the alumni preference, by which 35 to 42% of the children of alums of a place like Harvard get in, as opposed to 4 to 6% of everybody else. And as I was saying to Justice Duffley earlier, Al Franken, when in his funny days, actually in his book, Rush Limbaugh is a Big Fat Idiot, he, many years ago, captured the essence of the legacy admit program, which also is dealt with extensively in the Harvard case. He said, I'd like to speak to an affirmative action program, which is a Harvard graduate, I do like, and that is affirmative action for the children of Ivy League grads. He says there's a lot of good reasons for this. He said, actually, just one, money. But as it stands, it's an affirmative action program for one of the most privileged groups in the country, the sons and daughters of people like me, he says. And then he goes on to say, he says, now some argue that one of the poisonous and pernicious unintended consequences of affirmative action is that it taints the very real achievements of qualified black people who have earned their place at the table. He says, but you know, the whole time that I was at Harvard, I never once heard a Lowell or a Cabot remark, I dare say I despise this god-awful legacy policy. It makes me so suspect in the eyes of my classmates. How about you? So, you know, and then I just might add that then 90% of these folks, many of them have been passengers on the gravy train from the day of their fortuitous accident of birth in an economically secure family. 90% of these people graduate with honors from Harvard. If you graduate with honors from Harvard, you are in the upper 90% of your class. And it turns out that when Harvard and others were brought to vote for their legacy admit program by a group of Asian parents way back under Bush 1, who looks pretty damn good right now, really. When in fact a complaint was filed with the Office of Civil Rights at the Department of Education, what they found, and they analyzed the stats, was that these children of Harvard alums were not really very special at all, were they? They, in fact, had stats that were considerably lower than those who were not legacy admits, about the same as the people who were admitted on the athletic preference, which is huge in a place like Harvard, which comes out in the Harvard case. Basically, I think that the other thing that comes out in the recent Harvard opinion, which is a beautifully written 130 some odd page opinion by the trial judge, and that you really ought to read, is that there really are no proxies for race. And in that opinion, they go through every possible so-called proxy. And after the passage of 209, UCLA, which was much more aggressive than Berkeley law, UCLA attempted to do things like, all right, we'll give a preference for people in which at the home, English is not the first language. Well, they got a bunch of Russian emigres as a result of that. I think that also one other thing I wanted to say about Old Hall is that they refused to do a survey of their black graduates back to 71 versus a white cohort. And Michigan did do such a survey, professors from the University of Michigan, which found absolutely no statistically significant difference in the success of those minority students, the vast majority of whom had been admitted via an affirmative action program, and the white cohort. And to me, that means that the general criteria for admission obviously are racially discriminatory. There was, I only have 50 seconds more, but there was one very interesting factoid in the survey that they did, and that was that irrespective of race, that the tendency for someone to engage in public service work outside of their job was inversely proportionate to their LSAT score. Anyhow, I liked that. That was significant. One last thing which we'll come to is I was supposed to talk a little bit about the profession. The profession is a disaster right now for both Mexican Americans and other Latinx people, and for African Americans. I'll just give you one little set of statistics, which is right now, all minority equity partners, which is where all the money and power is in the legal profession, stand at just 7.6%. There are only 2% of all partners are African American, and 0.75% of African American women who are partners in those firms. And they don't even give equity partner statistics for African Americans, I think, because the numbers are so small. So right now you have a situation where African Americans are doing incredibly badly in the large law firms that are the catapult to power in this country for lawyers. And it's not likely to get a lot better anytime soon, although there are a number of programs at the ABA and bars across the country, and probably every single person in this room have launched minority council programs and so on. We can get into later what would really, where the hope really may lie. But I just wanted to end with a quote from David Wilkins, who basically said, quite a while ago, he said, "Few would dispute that the campaign to end legal segregation, culminating in Brown versus Board, is the legal profession's finest accomplishment, just as the profession's complicity in the regime that this campaign demolished was its darkest hour. The fact that the country's most prestigious law firms are nearly as segregated today," and this was in about 1999, still true, "as the entire legal system was 40 years ago, stands as a constant rebuke to the profession's attempt to claim the noble side of this heritage. As the legal profession confronts the uncertainties of the new millennium, it is the energy of recent initiatives of the type that are being pursued by so many in this room that holds the best hope for charting a new path that connects the profession's future to the best of its past."
Thank you. I'm going to follow just sort of asking for questions, but there's been mention about African American enrollment in flat for several years, 20 years or so. So I want to focus on human Sweatt for a moment. If he were applying today, does he get into law school? And this is open to any member of the panel.
I would say he would get into law school because at the time he applied, he was well qualified. The only reason why he was not admitted to University of Texas School of Law was because of his race. But it was quite apparent at the time that he was well qualified. And he would remain qualified today based on the same standard.
I don't feel any quarrel with that. I think it's clear that it's today. Although, the emphasis on LSAT, not just because of U.S. News and World Report, but you know, the ABA's section on legal education, which I regard as having done some terrible things in the last several years. But the most terrible thing that they did, and I don't know whether the chair of it is sitting here or not, I wouldn't know, but the most terrible thing that they did was to change the standards with respect to bar passage to significantly shorten the period of time in which the vast majority of people have to pass the bar. And the reaction to that is going to be that these schools are not going to take people that they think may not pass the bar the first time. And the idea that in 2 years, low income, particularly largely people of color, but of course everyone who's low income, to think that they can spend the money to reapply, to redo the bar exam and all of the cram courses and take the time to study enough instead of working and so on to accomplish that in 2 years, which is what the standard really requires, it seems to me is going to be disastrous. And that's why the House of Delegates rejected it soundly twice, but unfortunately the rules have changed, and after it doesn't pass the board of the House of Delegates twice, they can do whatever they want, and that's exactly what they did.
So in terms of, he and Sweatt would get into law school, would it be, when he get to the University of Texas, is he facing the same sort of choice? What would be different for him today?
As somebody at UT, I don't know. I don't know what he'd look like as an applicant. I don't think they had the LSAT then. And I don't know what his grades of rest of the application would be like. He'd get a fair shake now at our school of that. I'm quite confident, but I don't know what the result would be. I'm confident he'd get into law school. I don't know which law schools.
So, although African American enrollment has remained flat, the Journal of Blacks in Higher Education is reporting a gender gap among African Americans in the 2019 entering class at HBCU law schools. African American males comprise just over 25% of African American enrollment at those schools. And in 2 of those schools, they comprise less than 20%. Does this gender gap exist across law schools or just HBCUs, and what impact does that have on the Sweatt enrollment and more African American lawyers?
Well, I got kind of dizzy trying to look at all these statistical analyses, but there's no question that it extends across most law schools. Ironically, there are far more, in terms of what they call big law in the American law media, in the big law firms. In fact, African American men do much better than African American women, and there are larger proportions of African American men in the big firms, and they report more satisfaction. And there's been a lot of work done by the ABA and by many others about the double whammy of being a person of color and being a woman and so on. In the law schools, though, to answer your direct question, it's pretty clear that it goes across most law schools, and I don't know the answer to why that is, except for the huge economic burdens right now that perhaps African American men feel that if they're going to incur that kind of debt, they might as well go into a profession where they can do better.
And I have to concur with that. I think a lot of it has to do with the African American male having to go out and to earn a living, and it's very difficult at times to just take time away and to incur student loan debt and stay in school. And of course, for the African-American female, that student loan debt is just as difficult. But I think for men in general, getting out, getting employment and help taking care of a family is going to be very important to them. And you'll see many of them choosing that route rather than continue to go on to further education.
I'm just looking at the audience, and so if there are questions from you, we will entertain those now. Well, while you think about it, I have another, and that's the finance side. The issue of finances has come up a couple of times in terms of looking at African American enrollment. What are the issues they face in terms of how law schools dole out financial aid, student loans? What are they looking at?
Well, I think in terms of how law schools tend to dole out the financial aid, they dole it out based upon the merit rather than by financial need. And for the person of color in particular, oftentimes most of them do have financial need. And if they have lower LSAT scores, then they would tend to be the ones not getting merit scholarships. So the persons of color and those who have lower LSAT scores would have to finance their own education, meaning that they're taking on more and more student loan debt. Many of them are coming into law school already having student loan debt from their undergrad or master's program, so it's just compounded. And that then maybe also an additional reason why you're seeing the flat, you're not seeing that increase in the African American population applying to law school because of the high student loan debt.
Well, are you going to go ahead?
Go ahead.
No, I was just going to say, we haven't talked much about, the implicit bias area. Although I would like to quote the managing partner of a huge law firm, a very prestigious law firm, the former managing partner when he was still the managing partner at the time, and I said, do you all do training on implicit bias at your firm? He said, well, of course we do. And I said, well, do you think it has any real impact on the worst offenders? And he said, maybe he says at the margins. He said, but we just don't have to worry that much about implicit bias here at the firm. He said, because we have so much explicit bias here at the firm. And I would argue that one of the reasons that keeps African Americans from applying to law schools in larger numbers is because I think they are aware of the incredible amount of bias in the legal profession, which shows no real signs of abating, although there's been some really good work done by, it's a combination of the ABA and another organization about how to end bias interrupters, which are equally important in law school as they are in firms, to try to interfere with the kind of subjective decision making that is so completely susceptible to being infected by the biases based on stereotypes that absolutely pervade this country.
Well, I would only add to what was said earlier that it may be different between different schools or different sets of schools. I know at our school, it's very important for us to have a diverse entering class, and we work hard to recruit a diverse entering class, and we often lose diverse students over money. There are other schools that will provide more generous scholarship aid than we're able to provide. A lot of times, as I said earlier, those schools have scholarship budgets that consist of money generated through very large tuition. So I don't think it's the case that, well, I think I'll just leave it there. There may not be one answer that fits all schools when it comes to the relationship between affirmative action and scholarship support.
So, I think you mentioned the ABA standards on admissions and bar passage, and that the question about the African American enrollment remaining flat. will those standards lead to increased enrollment or less enrollment, or things stay the same?
Go ahead.
Anybody?
Well, the standards, especially as it relates to the admission standards, I think would cause there to be less enrollment of African Americans, because now there's this push by the ABA to requiring, and you see it with the law schools, they're ratcheting up the entering credentials of their classes, which means that they're shooting for higher and higher LSAT scores. That also bodes well for the law schools, that they're competing against each other for the U.S. News and World Report rankings and all of that. So who is losing out but those of color, and particularly African American, who tend to score lower on the LSAT, but tend to outperform their entering credentials in terms of being able to succeed in law school and pass the bar. That is overlooked because the law schools are competing against each other to improve their rankings, but also the ABA seeking to strengthen its accrediting arm. It's really looking at the law schools and requiring that they increase their scrutiny as it relates to the LSAT scores. So that is a problem for those, I think, worthy individuals who would otherwise would have gotten into many law schools but are finding themselves closed out because of the law schools' focus on LSAT scores. Even though law schools are saying that they're looking at applications holistically, they're still focusing first on the LSAT score. Once it meets that certain score, then they look at it holistically. And so a lot of, I believe, worthy people who would be become worthy lawyers are excluded from law school.
Well, and also they're frightened about the new bar passage rules. And, you know, I mean, the bar exams, there's just no question in my mind that they are discriminatory. And, you know, and it's funny, when I took the bar exam about 160 years ago, you know, there were 3 questions on golf. And, you know, you can't tell me that an upper middle class white guy isn't going to be more comfortable with that kind of a fact pattern than most women and most people of color. And so from the most subtle to much more blatant, I think that there's no question. And Marge Schultz over at Berkeley Law School did a huge study about what it is you should be looking at when you're doing admissions of law students. And she found that she interviewed something like she was with, you know, a sociologist who really knew what they were doing in a way the lawyers don't, but they interviewed a couple thousand lawyers really to ask them, what does it take to be a good lawyer? And it turned out they came up with 24, I think it was, criteria, of which the LSAT measured 4. And the others were things that sort of universally were thought by practicing lawyers of all races and genders to be what makes for a good lawyer. So if you have entering tests that in fact don't really measure the potential for success in law school and in the legal profession, and then you have a bar exam that doesn't adequately, accurately measure that in people of color, then you've got yourself a real trap, because the law schools don't want to go out of business, and if they under the new ABA standards feel that they're going to be found in violation of the standards, they're not going to take people that they see as risky. And diversity goes out the window at that point.
So this is a thought. Is that hand?
Yes, I have a question. So this question was really on. So as I did some research on the Sweatt v. Peter case and learned about Sweatt's experiences while he was in law school, there were many conversations about the fact that even though after he was admitted by the Supreme Court, that he was not well embraced by the students, so his overall law school experience wasn't very good. He didn't have the opportunity to have those conversations with his classmates about the legal cases that they were discussing. And even in some instances, he was required to sit outside the classroom and not be a part of the classroom inside. My question to you is, what is being done now to ensure that students of color have a good law school experience as they matriculate through the law school system?
Well, I appreciate the question. I'll say first, I think the evidence of what Heman Sweatt's law school experience was like is a little more mixed, I think, than you've described. There's evidence both ways on correspondence he wrote at the time about the way he was treated. But that's, I suppose, neither here nor there now. The question is, what are we doing now? And, you know, I think the first thing is we just try to be good at listening to students. It's very important to me, listening to students of color, all students, but certainly students from underrepresented groups. Ask, what is your experience like? And not to assume that there's one answer that fits everybody who's a member of a group, because it's not, you know, it's not the way it works. People have their own experiences, but try to listen carefully. So, for example, a few years ago, we had some students who were unhappy with the way that constitutional law was being taught, because they thought that the handling of some racially sensitive issues in their first year constitutional law class was not being handled in a way that worked well for them. They also didn't want to be the students in class who had to raise their hand and say so, because they didn't want to sort of identify themselves as being in charge of those issues or feel like that was the role of the class. But we tried to listen to these students, and what we did was we had our constitutional law faculty come visit with our Thurgood Marshall Legal Society, which is our Black Law Students Association, and just spend an hour letting students talk about it. What's it like at this moment in the life of our culture and in the life of our politics in this country? What's it like to sit through a discussion of this case or that issue that's handled in this way? What would you appreciate in hearing? What would one of your fellow students say that might have been a hard moment for you? And what would have been a productive handling of that moment in the class? And the faculty were able to hear this and listen to it and adapt. And I just think that's the only way. You've got to learn how to listen to people if you want to take good care of them and give them a quality experience.
Thank you. As a follow-up to this question, how many of you at your current law schools have conducted a survey amongst your students to determine that precise question as to how they feel they're being treated in the school with the environment? Because some law schools do that, and I don't know if your school has done that. If you have, what have been the results of it or the impact of it? Anonymous surveys, yes.
Well, I have not done an anonymous survey, but what I do have are town hall meetings, and I appreciate the importance of helping to demystify the law school process to them. Many students come in not appreciating what is involved with law school, what is required of them. So helping to demystify that, having a conversation with students. And I even though I am dean, I want to be approachable to the students and have them feel comfortable in talking to me about their concerns. So a lot of it's a concern, not a complaint, but having them talk to me about what they're feeling, how they're thinking, and making sure, similar to what in Farnsworth was saying, making sure that there are safe conversations around whether it's common law issues or others where they can talk to professors, having conversations with professors as well, especially being in HBCU. They're very aware of being able to talk about constitutional law issues in an environment where it is, especially with a critical mass of African-American students, there's a certain safetyness in being able to discuss issues as it relates to them personally. But even without a formal survey, when students realize you care, you truly do authentically care and really want to hear from them, it makes a difference. But demystifying the law school process, what is involved in going to law school, what's required of them from the very beginning, helps tremendously.
I'm not sure whether we take any surveys at SMU. I don't know what the administration does in that regard. I'm sure that they're taking steps if there are people who have comments to make. I know that every every year, there is an effort made, a law school-wide effort to bring up issues of diversity in class in the various subject matters. So that is done in SMU. That's something that the dean there has initiated, requesting faculty to either bring up issues throughout the year or especially during the month of February. I think during Black History Month, that may be a time when definitely some issues of diversity as they come up in a particular subject matter, they ask the professors to raise those issues. And I think the students made that request that be done, and that has been done.
Short answer, yes, we've done some surveys.
Have you done anything with that collective survey?
Yeah, we tried to learn from it and change our programming in ways that's helpful.
When I taught at I was dean much later, but when I taught at Golden Gate in the late 70s, there was an African-American professor a year or two behind, came in 2 years after, that some of you may know, Patricia Williams. And Pat Williams was from Roxbury, and she had been a civil rights lawyer, and she was really smart. Anyhow, so Pat did her first article, her first tenure article on, she found her great-great-grandmother's bill of sale, and she taught at the UCC, so she essentially took that bill of sale and sort of weighed it against the requirements of the UCC. Golden Gate was kind of considered the left-wing school of San Francisco, but there were a lot of professors there that did not sit well with. And she took a lot of heat from students because she was a black woman. There's absolutely no question this was a professor. And she really went out of her way to talk about these issues in her class and so forth. Anyhow, of course, she then took a leave of absence and she ended up tenured at, she wasn't quite good enough for Golden Gate, but she was tenured at Columbia, got a MacArthur Genius Award, was on the front cover of Mirabella magazine, went around the country with Anna DeVere Smith doing dialogues about race and that kind of thing. But she was not treated well at Golden Gate, there's just no question about it. And if she wasn't treated well as a professor, I'm pretty sure that there were bigger problems for this student.
That actually raises a point that I had a question for all the deans, if you want to weigh in, about black faculty and recruitment of black law faculty. Are there particular efforts to recruit and get tenured black faculty, as well as curriculum that you all mentioned some of the constitutional law courses, but I'm thinking of like civil rights courses or civil rights clinics that are very specific and that would also attract students of color.
When I helped to reestablish Florida A&M's law school, of course, we needed faculty. And it was important that whoever we hired understood the mission of the law school and the importance of the law school to Florida A&M. As many of you know, similar to many of the other HBCU law schools who were struggling at the time after the separate but equal was determined unconstitutional, and it was determined that integration was going to take place, and various states were reducing their funding to the HBCU law schools. So many of them were just going out of existence. And FAMU's law school lost its funding, and that funding went to start Florida State University. So at the time when the FAMU law students, or the original FAMU law school, was closing down and writing their exams, for the last class was writing their exams, the law school books were being transferred over to the new Florida State University College of Law. And so it's interesting that when the FAMU was reestablished, one of the first things that happened was that Florida State gave us back those original library books, so that meant a lot to us. But going back to your question, finding those, and it wasn't necessary that they all be persons of color, but persons of color not only appreciate the struggle that the Florida A&M law the school, the university had in terms of losing the law school, and the whole legacy, as you see with Sweatt and the other HBC law schools. But they also, many of these faculty members, they lived through certain things such that they would be able to impart or really enrich the class because they lived it. So it wasn't a matter of some professors who have this knowledge but somewhat distant of things and have painful feelings about it. Here are where professors can appreciate where the students are coming from and being able to help them, to heal them. Because if I really do think because of the structural racism that still is around in the country, when especially you see people of color coming into law school, they really want to make a difference. And as was mentioned before, the lower the LSAT score, the more they want to be more into community activists. They have to be healed first. So having faculty members who can understand and appreciate where they're coming from, and also to help to get them, not to be so offended and hurt that they can't do good for others. But we were very successful at FAMU in getting those persons of color, and not just people of color, but predominantly people of color, to become professors of law and do well there.
I did want to recommend Pat Williams. Her first book was called The Alchemy of Race and Rights, and it is just an outstanding book, really outstanding. And another great book is Marion Wright Edelman, who's going to be the Thurgood Marshall awardee of the section on civil rights and social justice. I have to put in a plug, I'm on the council. But we were lucky enough to get her to agree to be our honoree in Chicago this summer. She's written a great deal, but she wrote a wonderful book about mentoring and called Lanterns that I would also recommend, because it has a lot of stuff in it that is very much what Joan was talking about.
Briefly, I'll just say, I don't know of any law school where that's not considered a very important hiring priority, and indeed at the University of Texas, it's a university-wide, very strong initiative from the president and the provost on that.
I wanted to ask, George, are people who do critical race studies, have they had any problems with more traditional law schools that don't think that's something they should be doing? I know some of the feminist critical legal studies people have taken some heat, and I wondered what your
Well,
thoughts
I
are.
think that, yeah, that's been something that's happened. I think your example of Patricia Williams is something that may not be unusual may not be an unusual experience. I think that, there's a whole literature of dealing with problems for minority faculty. There's a book that's out that's called Presumed Incompetent, that especially deals with the experiences of women of color. That's a major book that's out that details all these kinds of problems, from difficulties with student evaluations and difficulties with faculties, other faculty, and so on. So it's something that has to be worked on at probably every law school.
Have you taken any heat because of this being your area of expertise?
Well, I got tenure and I've been promoted, so I can't complain too much. I think that universities all have, including University of Texas, has had some major critical race theorists like Gerald Torres, who was at UT for many years. So there are critical theorists that are on every faculty. So it's not that unusual anymore.
We are approaching the end, like a minute left. I just have one question that we'll close. To bring us back to Sweatt v. Painter and where we are now. So when I asked the question about the effect of the ABA emissions and bar passing standards, I think Bullock answered, because I think it does have an impact on Thurgood Marshall. So when I asked Dean Farnsworth, would that be a factor for University of Texas in terms of what happens with the admission of black law students in the future?
In a word, no, I don't think it affects our admissions at all. We're in the happy position of having students who mostly pass the bar, whatever their race may be, so it's not likely to have any effect on what we do.
Okay. I think that this has been a good program, and I'd like to thank the panelists. And enjoy the rest of the conference.